the said employee, Amos, disappeared after the said incident, never to be seen. In cross-examination, she informed the court that she did not know the said incident. PW2, Patrick Peter Mountainaga testified no. Was on his routine duties, the private number kept on ringing continuously, but he ignored the same since he was busy. Later, he engaged his phone on a flight mode for about 20 to 30 minutes so that he could concentrate and complete his annual reports. Later, upon disengaging from the flight mode, he noted that he had lost network. He realized not done. He received his Mpesa statement, the bank statement authenticating, and the money bank account, his Mpesa account, and the same was being withdrawn at some place in Mulot or Bomet. The first withdrawal was at 1914 hours, 150,000, 1914 hours, by someone in Dongo. The money was withdrawn at Mulot, Bomet. PW3, Dr. Jonathan Limo testified in court that he received a court order under miscellaneous application number 064 of 2022. They requested the Mpesa statements for 6 numbers. I will not be able to produce. Between 25th December 2021 and 6th of January 2022. He prepared and produced the Mpesa statements and subscriber details. It was his testimony that they were able to link the Airtel number 0727 and 90 and their details to one Beatrice Chelagat, and upon introduction she took them to one Naomi, and subsequently one Uele Chekimuni, the estranged wife to the accused, who indicated that the phone number belonged to his former husband. The police proceeded to the accused person's home at 5:30 a.m. with the said court order, and upon knocking his door, he refused to open, and they broke in. However, they did not find the accused in the house, but they found him hiding inside the ceiling. And they recovered a phone, a Phoenix phone, IMEI 592-701. I leave the other details. Registered in the number 0719-878713, registered under the name of Evelyn Chakamoy Teach. ID number, I leave also the ID number. The evidence available before the court points out, and the material which is produced before this court points out that the accused of the person who was using the line, which was receiving the funds, but had been registered by a different person so as to conceal his identity. The accused's defense is less animating that he did not commit the same offense. I observed the accused testify, and he did not impress me as a person who was candid for this case. Therefore, from the material and from the evidence, particularly from the mobile providers, that is Safaricom and Airtel, which was presented before this court, it's clear that the prosecution was able to prove its case and put out as required under the law. I hereby find the accused guilty under section 215 of the CPC for the offense of stealing, contrary to section 268(1), as read in section 255 of the Penal Code, orders issued accordingly. Investigation.
Staff got married, and also she's not, her body condition is not okay, and she developed tuberculosis. So I'm the one to take care of her in terms of food, and any other necessities. consider, and I'm also a father. Taking care of I have a child. And to take care of her since she was 20 months up to now. She's 6 years, and I've been taking care of her. And another thing is, my firstborn sister, Betty. Oh, sorry, my sister, firstborn, Betty. She also have a child with disability. And sometimes she considers me as a work. I mostly commit myself all the time. So it is my humble prayer to this court to consider me and also to give me another chance. Because there's nobody out there who is still behind them.
That's all.
And another thing is that mom's condition is not good. I'm developing a serious sickness that took her mostly. So I've been attending hospital maybe for checkup mostly. And the problem of hypertension. So that's my prayer for this.
So the accused is hereby found guilty. No longer an accused, you are convict, sorry. So you'll be held at the remand facilities the February, namely 1. Replace and repair the leaking roof. 2. Replace the worn-out clause on the premises. 3. Repair the loosely hanging electrical wires. 4. Replace all the broken and missing window panes. 5. Replace all the broken doors. 6. Clean by painting all the dirty internal and external wall surfaces of the premises. 7. Remove by demolition all illegal construction structures within the premises. The accused pleaded not guilty and further informed the court that they were yet to comply as they had been served with an order dated 19th of April 2021 from the tribunal. PW1, Michael Boyer, a public health officer, testified on oath that on 26th of February 2021 they were on normal routine duties when they came across a building which, after inspection, had contravened the Public Health Act. They looked for the caretaker, whom they found and introduced themselves to, and they found the building had worn out, chipped floors, hanging with wires, broken window panes, broken and defective doors. The paintings had faded, both internally and externally, and the building had extensions which were not in the initial plan. They served a notice to the manager owner to rectify their position. And upon going back for inspection, they found that the said notice had not been fulfilled. On cross-examination by the accused counsel, he informed the court that the premises would not have occupants and the issues listed are immediate debts. On cross-examination by counsel, which includes for the tenants, he informed the court that there was a notice dated 26th of February 2021, which was a sanitation notice, and upon inspection the building, he was shown the caretaker, whom he identified as the accused person. He further reiterated that the property was not fit for human habitation. His main role was that the rectifications have to be made if it was necessary for the tenants to vacate. He further clarified that upon visiting the premises for a second time, there was no compliance, and some houses have leakages and one cannot repair the roof when a tenant is present, and construction works cannot go on when they are tenants. Upon being placed on indefense, the accused Bishori Kareli testified in court that he was not the property manager, and he was also not a director of the property, and he did not fit the description as per the charge sheet. He admitted that the notice was issued subjectively since it was availed at his shop. further informed the court that he was the administrator of the estate of his father, the late Karevi Kinovia, and that Karevi Kinovia was one of the landlords. The others were Gerald Bashira, Mohammed Moha, Abeid Salim, Francis Buguti, Charles Maina, Peter Boru, and Karaoke Kashagu, and that the others were not served with notice. It was his testimony that upon receiving the notice, he took the same to Jimco Limited, who were the property managers and who collect rent and conduct repairs. They also informed the court that Jimco Limited had been appointed by the court. And the same notice was received by Jimco Limited. And they even got a renovation repair permit from Nairobi City Council. But the tenants went to court, and Jimco were restrained from conducting any repair. And this indicated that he was one of the tenants, and some tenants had sued Jimco Limited in the Rent Restriction Tribunal number 283 2021, that Jimco was restrained from disconnecting water and electricity. He further indicated that the subject matter was LR number 209/755, 16 and 17, and the owners were Gerald Bashira and Karevi Kinovia, who are both deceased, and that he did not contravene the notice issued by the county government of Nairobi. I've been able to peruse the submissions by the parties hearing, and the issue for determination of whether the prosecution has been able to establish its case beyond reasonable doubt as required by the law. Section 115 of the Public Health Act provides as follows, and I quote, "No person shall cause a nuisance or shall suffer to exist on any land or premise owned or occupied by him or of which he is in charge any nuisance." Section 118 of the Public Health Act describes what constitutes nuisance. From section 118(1)(a) to 118(1)(s). Section 118(2) provides the owner of a nuisance means the person by whose act, default, or sufferance nuisance is caused, exists, or is continued, whether he is the owner or occupier or co-owner or occupier or any other person. End of quote. Section 120 of the Public Health Act provides as follows procedure if an owner fails to comply with notice. Like this testified that Jimco Limited was the company in charge of the property who was appointed through arising from the fact that his father was one of the two registered owners of the property, the other being Gerald Bashira, who was also deceased. This court was never informed whether the administrator of the estate of Gerald Bashira was ever served with a notice of stop. Therefore, having recognized all the material presented before this court, it is clear that the property in question was under the management and control of Jimco Limited, who were the property managers. No evidence was presented before this court that the accused was a shareholder of Jimco Limited. The upshot is that the accused person was not the proper person to be available before this court, since it's clear from the evidence the property